I'm Scott Hemphill, a member of the faculty here. It's a pleasure to welcome you all to our forum. I'm delighted to have an all-star panel here to discuss the Supreme Court and the coming term. Let me briefly introduce our three panelists, and then we'll just jump right in. Paul Clement, to my far right, is former Solicitor General of the United States and also served as acting SG and principal deputy SG. He's argued more than 80 cases at the Supreme Court, an astounding 30 of those in the last 5 terms. Starting October 1st, he'll be a partner at Kirkland and Ellis. Paul was a law clerk to Justice Scalia. Caitlin Halligan is the former Solicitor General of the state of New York. She's argued and briefed many cases at the court. She co-chairs the Appellate and Constitutional Law Practice Group at Gibson, Dunn & Crutcher. Caitlin served as a law clerk to Justice Breyer. Finally, our own Bert Newborn is the Norman Dorson Professor of Civil Liberties at NYU Law and founding legal director of the Brennan Center for Justice here. A titan in the field of civil liberties, his most recent book is Madison's Music on Reading the First Amendment. So what I thought we'd do is talk a little bit about where we are at this moment. Surely the most important development is Justice Scalia's stunning death earlier this year. We'll talk a little bit about what that means for the court going forward, and then think about what we might expect in the coming term. So let me, if I can, just start with Paul. So with the justices passing with an 8-person court, 4-4 on some issues, what's changed with the loss of Justice Scalia?
Well, pretty much everything has changed. I mean, I really, don't think from the perspective of watching the Supreme Court, and I even think the lower courts, I don't think you can really overestimate how important Justice Scalia's passing was. I mean, you see that very concretely in some of the cases from last term. You had, cases like the public sector unions sort of First Amendment case, where I think every single court watcher, based on the oral argument, had decided that 5 justices were going to vote to overrule the Abood decision, and then it didn't happen, and the court was split 4-4. You had the immigration case, which was probably one of the 1 or 2 most closely followed cases from last term, and that was also divided, 4-4. So, when the biggest cases of the term are being decided in 7-word per curiam opinions that simply affirm the lower court, you know that the impact is substantial, but it goes way beyond that, because we certainly had, last term a number of cases that, even though they were decided on exquisitely narrow grounds. Maybe the most obvious example of that is the Zubik or Little Sisters of the Poor case, where the court, again, Justice Curiam writing, managed to, in that case, 5 pages instead of 7 lines or 7 words, but basically, an extremely narrow remand, essentially for the parties to see if they could work out their differences in the lower court, something I don't think, people who've been watching the court for decades and decades had ever really seen before. But even, in other ways, there were cases that were decided on, I think, much narrower grounds than they otherwise would have been if you would have had a 9-member court. As for this term, there are cases where I think the court's docket is pretty light, and with 1 or 2 exceptions that we'll talk about, is pretty plain vanilla. And I think that reflects the reality that, once Justice Scalia passed, I think the court was very, very cautious about granting new cases and really not wanting to grant cases when they were predetermined to be 4-4 splits. So you have that impact. And then the last thing I'll say is just in terms of, just the cascading effect of this. I just, if you, really, I think at the broadest levels, and there's certainly some exceptions, certain pockets of law, but, at a broad level, for about, 25 years, you've had conservative public interest law firms and law groups kind of playing offense and liberal public interest groups largely thinking that nothing particularly good happens in the Supreme Court, so let's stay out of there. And all of that sort of flips around overnight, and obviously will be accentuated if it turns out that Justice Scalia's replacement is somebody who votes very differently. So in the short run, you sort of have paralysis as everybody waits and sees what's going to happen in the election. But I think if the election, if Secretary Clinton wins and you have either a Justice Garland or a younger version of Justice Garland replacing Justice Scalia, I mean, it really is going to have kind of a Copernican shift in the legal landscape that's going to go down to the district court and the Court of Appeals level as well.
Caitlin?
I think that's mostly right, although I guess I think the shift might be a little bit slower and tempered by the tremendous effect Justice Scalia had on the court. One case I would add to the list that Paul put out in terms of where you may see different results going forward is something like the Clean Power Plan. That's the case involving the challenge to the Obama administration's climate change regulations, and the Supreme Court granted a stay at a very early stage of the litigation, which was very unusual. I think a lot of court watchers aren't at all certain how that case would break if it gets to the court eventually. The D.C. Circuit just heard it in bank, but that may well be a case where you have a 4-4 split instead of a 5-4 decision. I'm not sure this shift is immediately Copernican, though, because I think Justice Scalia so transformed the court during his time there in a couple of ways, both because of his just fierce intellect and also his tremendous gift as a writer. I think he really shifted, for example, the framework for statutory interpretation in a way that I think will stay with us for some number of years to come, by which I mean, I think there's consensus on the court now that even if you might eventually look at some legislative history if things are fuzzy, when you are answering the question of what a statute means, you start with its words. And I think that that's something that has become such a fixture in the court's method of statutory interpretation, in large part because Justice Scalia championed it so eloquently. And I think you also probably will have some force of precedent. Even if you have a Democratic president who has one seat to fill, perhaps more if there are additional retirements down the road, I think you still have a number of justices on the court who may be reluctant to baldly overrule, especially recent cases. So I think that may act as a brake as well.
Bert, as Caitlin mentioned, Justice Scalia was a fierce and influential champion of textualism. You didn't add originalism to that, though of course he was that as well. Thinking about these kind of twin intellectual legacies of textualism and originalism, do you think they fare equally well going forward?
I don't. Let me say first, I agree with Caitlin that the enormous, towering power of Scalia's intellect doesn't go away when he died. I mean, the effect that his intellectual power and personality had on the law, it may be among the most influential of the time that I've lived. And the most important is what she points out. When I graduated from law school, I've said this to a number of students here. When I graduated from law school, the idea of text, whether it was statutory text or constitutional text or even the text of an administrative regulation, the idea of text was seen as translucent. In other words, you went through the text to some deeper reality. And that deeper reality might be logical coherence, it might be purpose of interpretation, it might be harmony. I mean, there's all sorts of efficiency, all sorts of ways that you would go through the text and let something else do the heavy lifting and then come back and say that's what the text meant. The enormous power of Justice Scalia it convinced us that because of democratic political theory, we couldn't do that. We shouldn't do that automatically. What we should do is say that whenever possible, the judge should be compelled by the text, not go inside the text and rewrite it from the inside out. Now that's a tremendous, tremendous change in the way I thought, and I think the way my colleagues think of the law. And for someone who rejected almost all of the justices' political positions, I came to be totally persuaded by his argument that said, you start with text. And text is not just a window that you open to a deeper reality. Text is opaque. You stop with the text if you can do it. If you can do it with intellectual honesty and say that the text makes you do it. Now, the second thing is once text becomes hugely important, how do you read it? There, I think the Scalia influence will be a little less significant because he said, at least when it was constitutional text, you have some form of originalism. Usually now, the historical fact of what the public meaning was back at the time of the adoption of the Constitution. There, I think he never persuaded a majority of the court that he was right. And it was his intellectual power in keeping the argument going all those years that kept that idea alive. I think that conception of originalism as the only way to read the Constitution probably will go with the justice. I think Justice Scalia, if he's not there to reinforce it and to push it and to constantly goad his colleagues, they will slip into another way of doing it, which is the Souter's alternative, which is to say, no, you don't try to recover this as a historical fact. What you say is, what was the general purpose of the text, and how can we best construe it in the modern world to advance that general purpose? That's the version of, and that's when Ronnie Dworkin once said, we're all originalists. Because we all now believe that you go back and you look. But Scalia looked for a historical fact. Somebody like Souter looked for a purpose and then an effort to see how one advances the purpose in the modern years. That second version creates a lot of discretion in judges. The first version supposedly created less, but it collapsed because when you really did the historical work, you weren't sure what the public meaning was in 1787. They were as divided as we are on some of that. So my prediction is that textualism will remain the dominant way of thinking, but the way one reads text will change with Scalia's passing. And the last thing I want to say, and Caitlin mentioned it, I think Scalia functioned as the whip. He functioned as the whip of the five-person Republican majority on the Supreme Court. Now, I don't want to say that they behave in a partisan way. They do not. They do not. But they shared certain values. And Scalia was the person that maintained the discipline. When he's gone, people are going to stray from that. And I think we'll probably talk about Kennedy's two remarkably surprising votes at the end of last term. I think they may be attributable to the fact that Scalia was not policing the majority.
Let's turn to that if others have thoughts about that. I mean, we've talked a little bit about some of the cases, a little bit about methodology, at least as to textualism. You've now touched on, I guess, interpersonal dynamics, right? There's a certain amount of Kremlinology, I suppose, to use a dated reference, that goes into trying to think about how the justices might interact differently with a change in personnel. But do either of you all have thoughts about that? I mean, is Kennedy, as has been suggested, more freed up? Is Justice Thomas less enabled in certain cases? Do you guys have reactions?
I think that's very hard to gauge. I might leave that to Paul, who's probably a closer court watcher than I am. And you also have to wonder what the addition of a new justice will do to the court. It's a very small group. It's a group of people who have to live and work together year in and year out. I think there's probably a reason they all take the summer off. It lets everybody take a deep breath. But I will touch on one other piece of interpersonal dynamics where I think there is change already, and that's oral argument. Justice Scalia was a tremendous presence at oral argument. And you've been on the other side of that a lot more times than I have, but when he didn't like your point of view, you were damn aware of it. And if he did, you were aware of that as well.
I have bruises all over my body from those.
And I think he really, his presence on the court at argument made it into a far faster game, right? It struck me as a game of ping pong, except as the advocate, you're the ball, right? Back and forth. And, you know, I think if you look at some of the arguments after his passing, the tempo and temperature of them seemed a little bit muted. And so I think it will be very interesting to see how that plays itself out, both in this stretch where there isn't a ninth justice, and then depending on who joins and what their demeanor on the bench is like, how that continues to evolve.
Yeah, and just a couple of thoughts. I mean, one is just on what we discussed before. I mean, I certainly don't think there's any tension between what I was saying, which I do think this is really a huge shift in the legal landscape, and what Caitlin and Bert were saying about sort of the enduring legacy of Justice Scalia. Indeed, you know, I think it would be kind of shocking if I were the person on this panel, you know, not arguing for the enduring legacy of Justice Scalia. But I just don't think those are mutually exclusive, which is to say, I think he will continue to have a profound effect. I think, you know, unlike most associate justices who have served in my lifetime, or chief justices who have served in my lifetime, I mean, you know, I think people will still be reading Scalia opinions in law school 100 years from now. I mean, I think that's how kind of influential he was in articulating a view of how to interpret text and the like, and whether he ultimately persuades a majority of people over time, and whether his view kind of waxes or wanes, I think he'll still be kind of a reference point for it, because he articulated it so forcefully, and the man wrote so darn well, that the combination of that, I think, is going to make him, you know, his relevance really profound. But I still think that, notwithstanding all of that, that, you know, there really is, I mean, just if you sort of count up the justices, you know, it may be that all 9 of them at some level are textualists, but there are some positions that are a little more left-leaning positions where the text cuts in your favor, and I think those are the ones people will be pushing. And I think, you know, if you know, to the contrary, there are some issues where, you know, litigants have been pushing and thinking, well, you know, things will get better if I get it up to the Supreme Court, whereas now I think they'll think, well, I'm just not sure that's true. So I think those points are entirely compatible. I was really taken by Bert's sort of, you know, contrast of the Scalia approach to kind of original meaning versus kind of more of a Justice Souter approach to that. And you know, I think there's a lot to what you say about that. You know, I might shade things a little bit differently, but I guess what I would say is, just as a kind of interesting kind of experiment, it will be interesting to watch the confrontation clause jurisprudence of the court over the next few years. Because if you wanted a little sort of microcosm of kind of the Scalia view of, you know, of text and the primacy of text over purpose, you know, the confrontation clause is a perfect example, because the court's previous jurisprudence before Justice Scalia wrote the Crawford decision was essentially, hey, we know what the framers were on about. They were on about making sure that there was reliable evidence. And that was the broader purpose of the confrontation clause. And so the court started having some decisions where they admitted evidence even if the criminal defendant didn't get a right to confront the witness, just because they had other indicia of reliability. And the Crawford decision pretty effectively just exploded those cases and just said, no, we know what the framers' purpose was, reliability, but we also know the means to the end that they picked, which was confrontation. And so, you know, I don't give a fig, Justice Scalia said for the court, that the evidence might be reliable. If there isn't a right to confront, the evidence doesn't go in, and the defendant's position prevailed. Now, when he wrote Crawford, Justice Scalia had 7 votes for that position, which is a huge accomplishment in and of itself. To, you know, essentially overrule a line of Supreme Court cases and get sort of 6 of your colleagues to join is a pretty amazing accomplishment. But as the confrontation clause cases in the Crawford line got sort of harder and harder, and the evidence seemed really, really reliable, and the right to confrontation started to seem more trivial, like, what's the big deal if you got to confront the lab technician about a report or something instead of just getting the report in? You know, justices started peeling away. And so, over time, I think just the confrontation clause will be a good example of this, a good test case for this. Because, I do think that Justice Scalia made that argument about as forcefully as he could in the Crawford decision. If you wanted to find like one Scalia opinion that nicely encapsulated his approach to constitutional interpretation, Heller gets all the headlines, but it's really long. Crawford, it's much shorter, and it really will give you a great insight into his constitutional interpretation. Then the last thing I'll say, and I'll stop talking, but about oral argument. And Caitlin's absolutely right that weird things happened in the Supreme Court after February 13th at oral argument. Justice Thomas asked a question. Hadn't happened for a decade. But even beyond that, like advocates actually got time to make points. Yeah. Without having to field dozens and dozens of questions. But even so, if you go back and sort of rewind the videotape, or if you go to oyas.org and listen to some Supreme Court arguments from the 70s or the 80s, there were very few questions back then relative to even the sleepiest modern day argument. And, that really did change when Justice Scalia got to the court. He came from a D.C. circuit that was filled with legal titans like Pat Wald, Ruth Bader Ginsburg, Bob Bork, and the like. He was used to arguments where everybody was peppering the counsel, and he sort of took that mentality to the Supreme Court, which was a real change. And that's another area where I think, although sure, you can't replace a Justice Scalia, and you saw what happens when he's not there, the temperature goes down, the questions are a few fewer questions, but it's still, the impact that he had on the way that the Supreme Court does oral arguments, I don't think that's going away, especially because most of his colleagues now have kind of grown up in this. Elena Kagan is a great, effective questioner, and, you wouldn't say she's got lots of differences in the way she asks questions from the way that Justice Scalia asks questions, but she's got a lot more in common with Justice Scalia at oral argument than she did with most of the sort of pre-1985 justices who asked very few questions.
And Chief Justice Roberts grew up on the receiving end of some of Justice Scalia's questions, I think, as much
and
in
it's
the
payback
same.
time.
And he is tremendously skilled at it. Just for the record, I would not ever suggest that Paul was disavowing anything about Justice Scalia's legacy, and didn't mean to do so. But I think your look at Crawford is really useful in illustrating one other point about his approach, which is, as Paul was explaining, when you see the cases that follow Crawford, and the court has to grapple with the consequences of this rule, which can become very challenging. So, for example, a few years ago, the court heard a case about how the Confrontation Clause applies to DNA analysis. And it turns out that that involves a whole bunch of people. And so if all of the technicians who have touched the sample have to come and testify for the Confrontation Clause right to be satisfied, you're not going to have a whole lot of DNA evidence at a number of criminal trials. And I think what you really see in Justice Scalia is an adherence to principle, right? When he reads a provision of the Constitution in a particular way, that is, I think, what matters to him, and the consequences are to be worked out. In whatever way they have to be adjusted, legislatively, logistically, whatever it is. But I think that one of the things I'll be interested to see is whether some of the other members of the court who have struck me, Justice Breyer, for example, seems to me to fairly fall in this camp, as perhaps more focused on consequences, whether that has any more play in some of these debates, but especially in the Confrontation Clause area.
Well, for my sins, I've taught evidence here since 1974, and so have watched the Confrontation Clause wax and wane. Now you've let the cat out of the bag. I can't do what I usually do, which is to teach Crawford, but take away the name of the justice who wrote it. And I give it to the class, and I say, who wrote this? And inevitably, the class names the most liberal justice on the court.
Do you ban laptops?
I do. I banned extraneous knowledge. Everybody has a lobotomy when they come into my evidence class. But people are very surprised. Students are often very, very surprised to see that it was Scalia that wrote the Confrontation Clause, because it is such a strongly defendant-oriented opinion. Now, of course, you worry about Scalia's bearing gifts. At the same time that it became a strongly defendant-oriented, he also cut the Confrontation Clause into two pieces, because it now only dealt with what was formerly testimonial testimony, and lots of stuff that before would have had a Confrontation Clause problem were no longer covered by the Confrontation Clause because they're not testimonial statements. But having said that, I agree, it's a perfect way to look at the Scalia approach, because he's right as a matter of text. There's no argument as a matter of text. But then when you play out the consequences, you say, could they possibly have meant this? And then you have to deal with ultimately how to read it.
So let me shift gears a little bit. I'm going to start with you, Caitlin, if I can. We've heard a little bit about how we might see conservative groups moving from offense to defense and liberal groups moving from defense to offense. This is on the presumption, which remains to be seen, that we have a President Clinton and hence either a Justice Garland or a younger version of Justice Garland. If that isn't the case, then I'm not sure there's nearly as much to talk about, I think, going forward. But if we do see a court moving to the left, where would be the spots that groups would start to look to, whether it's, Second Amendment and the Heller-McDonald line of cases, or campaign finance or voting? Are there areas that are, and I'm going to ask each of you all this, are there just obvious places where we might expect either I suppose conceivably a frontal attack, or to just reverse an earlier constitutional holding, or maybe more realistically a kind of prying open by taking something that wasn't fully decided in previous cases?
I think you briefly touched on three areas. I have no clue who's going to win the election, but maybe my crystal ball is a little cloudy. So I think that the question about the next appointment will obviously turn on that. It will also turn on who holds the Senate, right? And I think that there's a wide range of questions there and possible outcomes. But in any event, let's assume you have someone who is either Chief Judge Garland or, as Paul put it, a somewhat younger version of Chief Judge Garland. You can look at campaign finance, you could look at Heller and McDonald, you could look at voting rights, you could look at high-profile, hot-button cases that are 5-4. But I think you also might want to look at where the court is about the power of administrative agencies and the regulatory state. That's part of why I find the Clean Power Plan case very interesting. It was argued a couple days ago before an in-bank D.C. Circuit, which now is a majority of Democratic appointees. And so if you have a Democratic president and you have an aggressive use of administrative agencies, then I think what the court does with those cases, especially in light of what has been, I think, some skepticism from the court about the reach of agencies, especially when they are making moves that really don't seem to square with the authority given them by the text of a statute, I think that those will be really interesting pressure points to watch. Maybe not as glamorous as the areas that you identified, or as immediately recognizable, if you turn on the TV or your phone, but I think very important nonetheless.
Paul?
Yeah, I'll talk about two areas. One is one you mentioned, one is one you didn't. I think the Second Amendment one will be, really an interesting one to watch. I guess kind of my money would be on the court not squarely overruling Heller and McDonald. I think that, those cases have been I mean, I've represented the NRA, so I will say to the frustration of my client, those cases have been in the lower court treated in a way that allows the vast, vast majority of existing regulations of firearms to be sustained under the Second Amendment. And, in some ways, that's a little bit counterintuitive, because if you think that, most of these laws were passed during a time period where the general understanding was that the Second Amendment didn't protect any individual rights, you would think that if the Supreme Court all of a sudden says, no, actually, that collective rights understanding tracing back to the Miller case from 1930, so 70 plus years, people have thought about it as a collective right, but the court says it's an individual right, you would think, wow, okay, well, that's going to mean that there's a whole bunch of state and local regulations that are unconstitutional, because that seems like that what would follow from sort of recognizing this kind of individual right that people hadn't really necessarily thought was operative. But in reality, most of the courts, seizing on certain language in the Heller majority opinion about reasonable regulations of firearms, have largely preserved the status quo ante. And so I think as a result, it just seems less likely to me that the court's going to really have a felt need to overrule Heller and McDonald, as opposed to just kind of construe them as, effectively cases about blanket bans on handguns. And I think, something of the irony of this is, I think if the lower courts had sort of applied Heller and McDonald more robustly and struck down a bunch of state and local laws, there might be more of a felt need on the Heller dissenters and the McDonald dissenters to flip those cases around. Now, I could be wrong about that, but that's just sort of my intuition about that area of the law. Time will certainly tell. The other one, that people, not just you, Scott, but other people in this context, really haven't talked much about, which is kind of interesting. I mean, it just sort of shows the kind of the ebbs and flows of legal issues, because for a while, federalism and the 11th Amendment was a really hot issue. And when I was in the SG's office, we were defending a whole slew of federal statutes that impose damages remedies against state governments under all, a whole bunch of statutes, the Age Discrimination Statute, the Americans with Disabilities Act. I mean, that was kind of the bread and butter of, our practice. And so, the federalism / 11th Amendment docket of the court was pretty active. Those cases sort of ran their course. There haven't been so many of those cases, so it's not front of mind. But, those are areas of the law where, kind of because there was a series of cases, the dissenters in those cases are basically on record as saying not only that they disagree with the majority opinion, but that they continue to disagree with the majority opinion. And, some of them even say, and if we get a chance, we're going to overrule, these majority opinions. And so, Justice Kagan and Sotomayor haven't voted on as many of those cases. So I suppose there's, a possibility that they'll feel like the pull of stare decisis is greater in that context. But that does seem one context I would really watch for, because, the justices, certainly Justices Breyer and Justice Ginsburg, are already on record as basically saying, not only do we disagree, but we don't really feel, much pull of stare decisis in this particular area of the law. So I think that's one to watch.
My sense is that a little history might be useful here. The Supreme, if in fact, I was so nervous during the debates. Caitlin and Paul will laugh at this. I couldn't watch the debate. I was so petrified that I was watching my candidates implode in front of me that I just couldn't watch the debate, so I turned on the Mets game. And then by the third inning, it was 7-0 Miami, so I had to turn off the Mets game. And I spent the evening in a closet with my wife coming every once in a while saying, "It's okay, dear, you can calm down, it's not so terrible." So I don't know who's going to win the election, and winning the election is what my assumptions are based on. If Donald Trump wins the election and there is a President Trump, there will be a nominee on the Supreme Court that will continue the Republican majority and perhaps deepen it. And you might see some very interesting cases. You might see the continued erosion of Roe. You might see the continued erosion of affirmative action. This is not a one-way street. Change will occur no matter who wins. And the question is which way change is going to occur. Historically, the Supreme Court's been an amazingly stable partisan institution. Republicans had control of the Supreme Court from 1870 to 1937. Democrats controlled the Supreme Court from 37 to 72, and Republicans in January of 72, and Republicans controlled it from 72 until Justice Scalia's death. So if a President Clinton nominates a Democrat, it will only be the second time since the Civil War that there have been 5 Democrats on the Supreme Court, and the first time was 1937 to 1972, and those of you who have taken con law know what happened then. There is the possibility for an extraordinary change in the nature of the court. Dean Morrison and I were at doing a strategy session yesterday at the Brennan Center, and we both cautioned that if you look at history, if you look at 1937 and you look at 72 and you look at the period after that, do not expect wholesale overruling of Supreme Court precedents. It doesn't happen. It shouldn't happen. The Supreme Court is not a third house of the legislature, and just because you have 5 Democrats who might have voted differently on a past case, the whole idea of stare decisis, even at the constitutional law level, because I've argued that strongly for Roe for years. I've defended Roe on stare decisis grounds. You do not simply throw away a generation of Supreme Court precedents because you now have 5 votes. And if you do that, you have badly wounded the Supreme Court as an institution and the rule of law as something that we can depend on. So not only do I think it's a bad strategic thing to happen, it won't happen. And if the progressives push the court into trying to go too far too fast, they will push the court into a fortress position in which all 9 members will line up and say, we are not partisan figures, we do not vote that way, and you will have a replay of areas in the past where overreaching results in a retrenching by the court. So you have to be very careful about where we go. Now, where might we go? I think a very important place to go are the compulsory arbitration cases. I think access to the courts may be a very interesting issue. And the nice thing about the compulsory arbitration cases is that they're statutory. And not only are they statutory, they're statutory and based on a series of precedents beginning in the 1980s that overturned earlier precedents. So that you have a history of overruling in that area. And I think there are 4 votes now for maybe even 5, because Justice Thomas doesn't like the principal 1980s case that did this, and he's on record as saying he thinks it was wrong. It's a preemption case. It's possible that the compulsory arbitration cases will be very important. If it were me, if I were pulling the strategies, I would say you want to minimize any case in which you have to ask for a formal overruling. So what you might want to do if you want to deal with gun control is do just what Paul said. You go up there and you argue, Heller is a mistake, but it is your mistake, it is our mistake, it is now embedded in constitutional law, it is a rights-bearing opinion, and you don't overturn rights-bearing opinions. But you can impose a rational basis standard on it. And if you impose a rational basis standard on it, you've pulled its teeth. And it doesn't have much of a or you say McDonald is the problem. McDonald applied the Second Amendment to the states so that we have a one-size-fits-all rule all over the country. You could have a Second Amendment that binds the federal government and then leave the states to try to localize the rules in accordance with local traditions. And the nice thing about that from my standpoint is McDonald, the case that said that the Second Amendment applied to the states, doesn't have a majority opinion. It was 4-1-4. And Justice Thomas refused to endorse the majority way of thinking about it. He wanted to go all the way back to the slaughterhouse cases and overrule the slaughterhouse cases. So that's a vulnerable place. And the last thing, just generally, is the equality cases or places to probe. If I had one case that I would try to get them to overrule, It is the case that begins the Republican domination in 1973. It's the case that upheld unequal funding of public schools. That you could have, for example, Texas uses property taxes to fund public schools. So Plano, Texas, which is a really rich area of Texas, has extraordinarily well-funded schools. San Antonio, which is a very poor area of Texas, or was at the time, has very, very poorly funded schools. And there's very minimal equalization. So a kid in Plano gets a much better funded education than a kid in San Antonio. That was a 5-4 case. If I had one case to go after, to kick off the thought that equality makes a bigger difference in the new court, it would be that one.
Do either of you guys want to follow up on any of what's been?
Okay. Looking ahead, so we have a new term coming up. As you've already heard, it's a little bit on the thin side so far in terms of the set of cases that have been granted cert. But there are a few gems in there, so I think we might talk through a couple of those. And Paul, maybe I'll start with you in the Trinity Lutheran case. I guess this is the scrap tire grant program case, but that's probably not the most attractive way of explaining this free exercise, equal protection matter.
Yeah, no, it's an interesting case, and perhaps it's no accident that this is a case that was actually granted before February 13th. So this was a case, as I alluded to before, once the court knew that it was dealing with an 8-justice court, it sort of went into a little bit of paralysis in terms of staying away from cases. And, my own suspicion is that if this case had gone up to the court after February 13th, the court probably wouldn't have granted it, to be, perfectly honest, because I do think it's a case that's likely to divide the court pretty closely. But the court did grant this in January. Interestingly, it granted this case at the same time as some other cases that were actually on the same conference that were actually briefed and argued last term and already decided. So what that normally means is that this would be a case that would be slated for argument, next week or the week after in the October sitting. But this case was not scheduled for the October sitting. It was also not scheduled for the November sitting. And
Can they wait it out?
what's that?
I mean, can they really wait it out?
They could try. And I have no insight into why that happened. I mean, could just be that, somebody's dog got sick twice in a row or something.
But it's unusual.
But it's unusual. And it does sort of suggest that maybe the court knows that this is a case that's going to be divisive. Because after all, they voted at the cert stage, so they kind of know where the cert votes were anyways. And it may just be that they're, in no particular hurry to schedule this case. Now, we'll find out. The December calendar should come out in a couple of days, and, maybe it'll be scheduled in December. But even that's a little unusual. But just to give you the case so you can sort of, see why it is, I think, a very interesting religious liberty case. As Scott suggested, sometimes Supreme Court cases come out of funny places. The Missouri scrap tire program doesn't seem like the font of a big constitutional religious liberty case, but that's what happened. Also, I have to say, and this is like the litigator in me, but this case is just so exquisitely presented in terms of cutting away all of questions that often bedevil a case like standing and things like that. Because here's what this program does. It seems like a fairly sensible, sort of good government thing. It imposes a special tax on new tire sales. It takes the money raised by that special tax and it allocates it essentially to take the old tires, scrap tires, instead of having them go into a landfill or something. They get sort of all cut up. They get reformulated into these foam things that they can sort of pour onto playgrounds. So, it seems pretty good. You save the environment a little bit. You keep kids safe. I mean, what's not to like, right? But in Missouri, they have a state constitutional provision that you could loosely describe as a Blaine Amendment that is kind of more sort of prohibitory of state sponsorship of religion than the federal Establishment Clause. And it's written in a way that basically says no aid shall go to a sectarian institution. And so under the state constitution, the Attorney General took the position that, based on a state Supreme Court case, that the funds for this, for safer playgrounds, could go to any kind of playground in the state as long as it wasn't affiliated with the church. And so that's the position, and that's what's being charged. And here's the part that the litigator in me loves. Notwithstanding that, the state sort of processed this request, and on an annualized basis, the state gets more requests for funding than they can fund. And based on totally neutral secular criteria, they rank the various proposals. And so they had like 40 proposals. They could only had enough money to fund like 15 of them. And when they ranked these programs, or the applications based on secular criteria, this church-affiliated playground was like 5th on the list. So, like, it's just like I said, you're used to like worrying about standing or redressability and stuff like that. This is beautiful. Like, that but for the religious affiliation, this playground was going to get the money for a safer playground. They didn't get it. We know it was for one reason and one reason only, and that's this interpretation of the state constitutional amendment. And then that was challenged in federal court under the grounds that the state law essentially requirement that there be discrimination against religion to avoid a state sort of establishment clause type violation itself violates the federal constitution. Some version of either the free exercise clause or the equal protection clause prohibits that kind of discrimination against the religious entity, the religious affiliated entity. So what this case implicates is then one of the hardest parts of interpreting the religion clauses, which is this idea that's been repeated in a number of cases that there should be some play in the joints. Like, the governments shouldn't be in this position where either they establish religion and violate the Establishment Clause, or they discriminate against religion and violate the Free Exercise Clause. There's got to be some sort of narrow channel where they can actually get it right. And then if you put on top of that the kind of federalism notion that, generally speaking, states can overprotect rights so that, even if the federal constitution doesn't have like a particularly robust exclusionary rule in some situation, a state, in interpreting its own state constitution, is free to have a very robust exclusionary rule in that situation. But here, the question essentially is, in overprotecting an anti-establishment right, does the state effectively violate a federal free exercise or non-discrimination norm? That's a hard question, I think. I think it's a legitimately difficult question. And I think it's, I think it's going to be, I don't think it's going to be super obvious how the justices decide this case. I think the more conservative justices are probably going to be more sympathetic to the claim of discrimination in this context, and I think the more liberal-leaning justices will be more sympathetic to the sort of prerogatives of the state. Sounds a little backwards, maybe, but I think that is probably how it's loosely going to sort out. But how this case gets decided with a 9-member court, I'm not sure. But I do think it is an interesting, important case that, legitimately will probably, unless they end up having to decide it with 8 justices, and then, find out that like the form that was used here was purple instead of blue, so it has to be remanded. I think this is one that is likely to divide the court.
So, Bert, how should this case come out, do you think?
I'm sorry.
No, perfect. It's a perfect question. I was going to say to Paul, I don't know which side you're on the case, if any side at all, but my strong intuitive feeling is that the challenger should win. That I don't see the great risk of religious oppression about letting kids play safely in church schoolyards. I just don't. It seems to me that this is one of those areas, and the Blaine Amendment is. So it cycles back to a federalism issue. The Blaine Amendment is a constitutional provision that was adopted at the level of states in a number of states during I hesitate to say, but it's true, a very strong anti-Catholic period in American history. And it was designed to cut off funds from parochial schools, cut them off, absolutely. And it is the law in a number of states. It's a very strong, much stronger prohibition than the Establishment Clause is, than the federal Establishment Clause is. It's sort of the Establishment Clause on steroids. And so the question really for me is not how the case should come out. If it was an Establishment Clause case, I don't have the slightest doubt then that we would say that, of course, this is a secular purpose. Its primary effect is not advancing religion. It would be discriminating against religion if we didn't let the religious kids be as safe as the secular kids. So why not say that it's not a violation of the Establishment Clause? I think that gets 9 votes on the court, including the person that isn't even there yet. That's how sure I am. But the harder question, and as the way Paul puts it, the hardest question is a federalism question. Do you want to say to Missouri that if you really care about Establishment Clause values, that the way that the feds are construing the Establishment Clause isn't protecting those values enough? And that what you want is a super establishment clause that really, really protects those values, even if it treats religion worse than secular activities. That would not violate the federal establishment clause. Does the free exercise clause kind of crack back and knock out Missouri's decision to have a tougher establishment clause than I think many of us in this room would vote for? And my federalism position is maybe that should be up to Missouri. That this may be a very foolish and bad law, but that I'm not sure that we should take the power away from Missouri. So I honestly don't know how the case is going to come out, because it's got those conflicting issues.
Let me turn us to a second case, and I should say in a few minutes I'd like to get questions from the audience. So start thinking about your questions. We're not there yet, but I want to go ahead and put you guys on alert to be thinking of some stumpers for our panel here. So the Pena, is it Pena Rodriguez or Pena? It must be Pena Rodriguez, probably, versus Colorado. So this is a Sixth Amendment right to impartial jury case. I guess raising is it the impeachment rule?
Yeah, so
Can you
it's
tell us
a
about that?
really interesting case. Just to circle back for a minute to the Establishment Clause free exercise case, I think those are very sticky wickets a lot of times. But the one thing this has resolved for me is I now know where all that stuff on the playground comes from. I've been wondering that for quite a number of years. Pena Rodriguez, really fascinating case that raises the question of what happens when the interest in protecting the sanctity of juror deliberations runs up against the Sixth Amendment right to an impartial trial. So the case arises in Colorado, but the state evidentiary rule that's at play there is pretty much the same as the federal rule. The U.S. is in this case for that reason. Many states and the federal rules of evidence as well have a rule that says that if you are inquiring into the validity of a jury verdict because you believe it's been improperly tainted in some way, the juror testimony about deliberations is not admissible because you want the black box inviolate, right? And there are plenty of reasons for that. It's a rule that has its roots in the common law, and one that Congress has acknowledged is important to protect free deliberations. There are a couple of exceptions to the rule, though. One is testimony about extraneous information. You know, I went on Facebook and checked out the witness, and, you know, I found out the following. Also, outside influence. Someone stopped me on the street and said, you know, I'll give you $1 million if you vote this way, or you'll regret it because I'll beat you up, whatever it is, or a technical mistake in the verdict form, which does happen. So it's not an absolute rule. And also, there are a number of states that do allow for some inquiry. So what happened in this case is that you have a verdict for, I think it's attempted sexual harassment. It was a man who sexually assaulted a couple of teenagers in a restroom, I believe at a state fair. And it came out afterwards, you know, generally after a trial, the lawyers will talk with jurors if the jurors are willing to do so and ask them questions about why they reached the decision that they did. And a couple of jurors indicated that one of the jurors made comments about believing that the defendant must be guilty because he was Mexican and because, in that juror's view, Mexicans were likely to engage in this kind of conduct, particularly Mexican men. So clear racial bias, really that's not at issue. The question is, can that testimony about what happened in the jury room be used as evidence in an effort to set aside the conviction? So the court said no, because the rule said that it couldn't be. And the question's teed up for the court. So on the one hand, you have the defendant saying, first of all, racial bias is essentially unique. It is uniquely corrosive of the fairness of a jury trial. They also say, number of states allow these inquiries, and we also allow some testimony, for example, about extraneous influence. So it's not like the box is sealed, the jury box is perfectly sealed and impermeable in any event. And they also argue that, it doesn't come up in too many cases, although there's really a sort of chicken and egg issue there, because if the rules say you can't put the evidence in, it's not clear that it would be presented so often. The U.S. and Colorado both say, look, there are plenty of other mechanisms to deal with this. And in particular, in this case, even though the judge said to defense counsel, and in the government's presence as well, that sometimes jurors tended to bring racial bias into the courtroom, defense counsel opted not to inquire into that during voir dire. Now, there might be tactical reasons to do that. You might be worried about alienating your jury pool. The defense counsel also declined to ask for a jury instruction, which would have told the jurors, you may not take into account these sorts of factors. And the U.S. and Colorado say those are safeguards enough. And they also say, look, certainly racial bias in the jury room is unacceptable, but where do you draw the line? And how do you fashion an argument that racial bias is somehow more corrosive than any other kind of bias? And if that's difficult, once you open the Pandora's box, then have you really exposed jurors to a lot of interrogation, perhaps harassment, and made it much more difficult for jurors to be free and open while they're deliberating, as opposed to thinking about what might happen down the road. I don't have a good sense for how the case is going to come out, but I certainly think that it is an interesting one. I think the government may have a powerful argument that it is difficult to find a coherent reason in the law to draw the line at a particular kind of bias, as opposed to thinking about it across different kinds of motivations.
Do you have any ideas about a line?
Just a very short observation. Caitlin's presentation of the case is terrific, and I have nothing to add to that, but it raises an institutional issue that has long troubled me. And she was talking about strategic considerations that might have led the defense counsel not to voir dire on potential racial discrimination. One, you don't want to call attention to the fact that the defendant is Mexican, and two, you don't want to somehow stir up feelings in the juror pool about race that might otherwise have been there. So it is not a crazy thing for a defense lawyer to have said, gee, I wish I could inquire, but I think on balance it's too dangerous. I've been confronted with that problem myself, not on race, but on a number of different voir dire issues. It's always struck me, because race is so difficult and such an important issue, that the voir dire on race should be conducted by the judge. You shouldn't leave the defendant with the choice of either alienating the jury or perhaps here waiving a very important right. There ought to be some statement preliminarily, prophylactically, by the judge herself about making sure that jurors understand their duties to come into this case race-free and to put aside their sense of racial bias, and asking some questions, some just general questions of the jury pool that might result either in a peremptory or a challenge for cause. It's just something to think about, whether or not we ought to locate the responsibility. In the Southern District, a number of federal judges ask the racial question themselves first.
I think another thing that's challenging about the case is that it's presented here in a particularly unvarnished and ugly set of facts, right? If the comments that the jurors recounted are accurate, they were very plain evidence of racial bias. But when you look at jury pools, for example, in New York City, I don't know how many of you have been summoned to jury duty and sat in the room with, the 100 other folks while they go through and pool jury. But that jury pool largely reflects the racial and ethnic diversity that, of course, is in New York City. And so figuring out what counts, figuring out what remarks are explicit enough, I think could be exceedingly challenging. And so, the government captions this interest as sort of finality, right? I think that it may be one that is about administrability as well as finality.
Y'all's turn. Questions? Don't be shy.
Nobody leaves here
Yes.
until there are questions.
Wait for the microphone. Then. Is that another class technique?
There's a sort of interesting equal protection question coming up in Morales-Santana, I believe, and I was curious of your thoughts about what you think the court might do there, or your thoughts about the case generally. It's about whether the length of time a citizen parent has to have resided in the United States before their foreign-born child will grant citizenship, and for mothers it was 6 months, and for fathers it was something like 12 years, I believe, maybe 13 years. So I was curious if you have thoughts.
I mean, I'll just offer, my quick thought, which is, when you present the issue that way, but I mean, seriously, it seems like a really, really easy case that, of course, that's discriminatory and is really problematic. I think the thing that maybe makes it harder is that, if you go back historically, these kind of differentiations between the mother and the father for purposes of, immigration status and citizenship status and have a long history. And, you may say, well, it's a long, ugly, discriminatory history. But, it's the one thing that I think, that maybe sort of gives the government a little bit of an argument in terms of trying to defend these, that this is not just some sort of one-off, obviously discriminatory thing that, clearly should fall by the wayside. And the court has had a couple of these cases. I was never involved in any of them, so I haven't studied probably as closely as you have. But, the court in some sense, I think, has made these cases more difficult than maybe they seem at first blush. So I think, although, like I said, it seems like it ought to be pretty open and shut, frankly, I think the court will probably struggle with it a little bit.
Yes. Just grab the mic first, sorry.
Just wondering if you had any thoughts on US v. Salmon.
We're glad you asked.
That's one of Paul's and
Please.
my favorite cases. Since I started last time we did this, why don't you go ahead?
Sure. No, but we really are glad you asked, because there was the one case that both Caitlin and I really wanted to talk about.
If no one had asked a question, I would
We
have
both
asked
think
about
it's
Salmon.
super interesting and
So
go for
I'll
it.
just give you sort of my perspective on why I think it's super interesting. And, I've represented a couple of defendants in insider trading cases, so, that may, sort of influence my views a little bit on this. But the question in Salmon, in case not everybody is instantly as knowledgeable and excited about it as Caitlin and myself, the question is, what kind of benefit does the tipper have to get in order for the tippee to be liable for insider trading, or the tipper? Because the liability of the tippee turns on the liability of the tipper. So to understand why that's the question, take a step back, okay? Insider trading, gosh, that sounds bad, right? That's got to be against the law. There's got to be a federal, anti-criminal insider trading statute to get, people like Milliken or whatever. That's just bad, right? So, yeah, at some level, academics can sort of debate how bad insider trading is and all that, but insider trading is pretty bad, and there probably should be a federal criminal law that specifically addresses it and says, look, this is really bad, here are the penalties, and these are the metes and bounds of what makes it insider trading. And so you think of a classic case where you're the insider, you use your insider information to trade on the stock of the company for which you work, and you make a killing. Yeah, you should go to the pokey. That should be against the law, you should go to the pokey. But the problem in this area of the law is that the criminal statute under which people are being deprived of their liberty for insider trading is 10b. It's not an insider trading statute that talks about the specific metes and bounds of people's criminal liability. And 10b basically says that it can be criminal to engage in fraudulent, deceitful, and manipulative practices in connection with security. Well, what the heck does that mean? At least as to the specifics of when insider trading is problematic and when is it not. So a doctrine develops that basically says, and it stems from a Supreme Court case called Dirks. The basic rule is, look, it's not a crime to trade on insider information. So if you overhear somebody on the subway who says, "Hi, I'm talking on their cell phone really loud and stupidly. I'm an insider. We're going to go public tomorrow. We're going to have this merger tomorrow, or whatever." And you hear the name of the company and you think it's legit. Trade to your heart's content. And the Dirks opinion not only says that's legal, but sort of hints that it's actually, it's good. It's like a social good. It's a lubricant of the market. Free markets, there's sort of a flavor of that to the Dirks opinion. But if you happen to get that same tip from a buddy of yours who got it from a buddy of his, who got it from a buddy of hers, who got it from an insider, then the law depends on whether the insider violated the fiduciary duty to their company. Now that's easy when they're trading on their own account. But suppose somebody gives it sort of gratuitously to somebody who's a friend of theirs. Does that violate the statute? Well, the U.S. Attorney for the Southern District certainly thinks so. And indeed, he will prosecute anything that even sniffs a little like a gift.
In fact, you might be liable for the riding in the same subway car club.
Yeah, because after all, that's a close, personal relationship. You
yeah.
pick the same car.
Especially if the guy gave you a seat.
Well,
there you go.
then that's easy. That's easy. No, so the benefit standard has, over the years, in a number of cases in the Second Circuit, had gotten very, very loose, so that almost any kind of benefit would do. The Second Circuit got a hold of this in a case called Newman, and in the context of that, really tightened up on the sort of traditional sort of Southern District of New York District Court sort of standard for benefit. Again, used a formulation about the nature of the benefit that has no mooring in any statutory text at all. So even though it made things a lot better, it's still not, from my humble standpoint, very satisfying. The Ninth Circuit had another case, the Solomon case, in one of these just kismet kind of situations. Who ends up on the Ninth Circuit panel but Judge Rakoff?
Who's on the Southern District,
Yes,
District Court judge.
Exactly, who is used to applying the old sort of loose benefit standard, which all of a sudden now becomes the law of the Ninth Circuit. I'll turn it over to Caitlin just with two more observations. One is, what makes this really interesting to court watchers is when the Newman case came out against the government petitioned. Now, the government rarely petitions to try to get a more expanded scope of a federal criminal substantive statute. They hadn't really done it in like a decade. So most court watchers thought, of course, that petition is going to get granted. I mean, the government gets like 80% or higher of its petitions granted. But the Supreme Court stiffed them and didn't take that case, which I think really surprised people. Mm-hmm. But then when the Solomon case comes out the other way, in the Ninth Circuit, they take the criminal defendant's petition. So it's teed up. What the court does with it, I'll let Caitlin sort of, prognosticate a little or whatever she wants to say about it. The one thing I will say is, having worked, on behalf of some defendants in these kind of cases, my takeaway is, I have 3 sons. I would not let any of them become traders. Because it's a crazy system we have right now. Because, your job as a trader is to get better information than the market. You're trying to get it from all sorts of sources. If you get information that's really good, you get a promotion. If you get information that's really, really good, you go to jail. And it's just kind of a crazy system. And I'm not like pro insider trading. It's just like, as with any other criminal law, you just like the lines to be crystal clear. And if you tell me I can never do X, I'll never do X. And it just seems like we're so far from this that it will be really interesting to see how the court processes it. If they process this the way they have honest services fraud, they should view this as an easy win for the defendant. But if they process this through the lens of insider trading is really, really bad, and the facts of the Salmon case are not the best for the defendant, it could come out the other way.
Well, that's also interesting because the facts in Newman were way better for the defendant. Paul captured perfectly, I think, the problem with the government's point of view here, which is the law doesn't address this explicitly, it doesn't outlaw it. The standards that the courts have laid out are completely indeterminate, and the prosecutor's offices have tremendous amounts of discretion, and it's a criminal law, so we're supposed to be on notice as a constitutional matter of what conduct violates it and what conduct doesn't. Here's what makes it even tougher, though. On the other hand, if the rule is that only a pecuniary gain counts as a sufficient personal benefit, then here's what I think it means. It means that I can stop putting money in my daughter's 529 account if I simply can get some tips and tell her to go trade, right? It's the friends and family plan on the other side of the balance. And so I think the court will be very sympathetic to the points that Paul has laid out, and I think the question for them will be, can they fashion a rule, or do they want to fashion a rule that is a little bit broader than pecuniary gain, that captures something of some real utility, but still is definite enough that it gives courts, and more importantly, Paul's sons and my daughter and every other putative defendant out there, some guidance about their conduct.
Okay, 20 seconds, okay? 20 seconds.
I would take this one out on the void for vagueness doctrine. I think the statute has reached the point where it does not give constitutionally sufficient notice. A term ago, they struck down the sentencing provisions in one of those, and it surprised everybody that they went to vagueness. I think they're primed maybe to go to vagueness again if somebody pushes them very hard. It says, we're not going to strike the whole statute down as facially vague, but it's vague as applied at the periphery where nobody can reasonably understand what it means. And I think that would be right. It would force Congress to do its job, which is to draft an insider statute.
Well, this was terrific. Please join me in thanking our panelists.